The United Nations General Assembly this week passed Resolution A77L58, requesting the International Court of Justice issue an advisory opinion on the obligations of states in respect to climate change. This resolution, sponsored by more than 100 countries, was the culmination of a 4-year campaign led by the government of Vanuatu, a small Pacific island state that has been one of the leaders on the issue of climate change. The resolution was adopted by consensus, though neither the United States nor China would officially support the resolution. Nevertheless, the passage of the resolution was welcomed by the international community. So what happens next? What are the potential implications of the International Court of Justice's advisory opinion on global climate policy and on the future of international law? Hey everyone, I'm Noah Zerbe. I'm a professor of global politics at California State Polytechnic University, Humboldt. Welcome to IR Explainer, where I examine the concepts and theories behind current events in international relations. There's a lot to unpack here, so let's start with considering the resolution itself. The United Nations General Assembly is an international forum where 193 member countries come together to discuss and coordinate policy on global issues, and climate change has become a significant concern for the organization in recent years. With the increasing recognition for urgent action on climate change, the General Assembly resolution passed yesterday requests the International Court of Justice, or the ICJ, provide an advisory opinion on the legal obligation of states under international law regarding climate change. This move, in short, aims to clarify the responsibility of countries in addressing climate change and to promote more ambitious and coordinated efforts. Now, what does it mean for the ICJ to provide an advisory opinion? The International Court of Justice is the primary judicial organ of the United Nations, and its role is to settle legal disputes between countries and to provide such advisory opinions on legal questions submitted by UN organs and specialized agencies. While the ICJ's judgments in contentious cases can sort of be legally binding on the parties involved, its advisory opinions are not binding. However, they nevertheless carry significant weight in shaping international law and influencing the behavior of states, and that's what Vanuatu and the other sponsors of the resolution are hoping for. The resolution specifically asks the court to answer two questions. First, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And second, what are the legal consequences under these obligations for states when they, by their acts or omissions, have caused significant harm to the climate system and to other parts of the environment with respect to states, including in particular small island developing states, and peoples and individuals of the present and future generations affected by the adverse effects of climate change? So what can we expect from the ICJ's advisory opinion? While it's hard to predict a specific outcome, the opinion could potentially address several key questions and aspects of climate change obligations. Any opinion will likely be rooted in the principle of common but differentiated responsibilities. This principle, enshrined in the UN Framework Convention on Climate Change, or the UNFCCC, acknowledges that countries have a shared responsibility for addressing climate change, but that their individual obligations should reflect their differing capabilities and historical contributions to the problem. In other words, recognizing that all countries have some responsibility for addressing the challenge of climate change, the common part, it also recognizes that not all countries are equally able to take specific action, and that not all countries have contributed in equal measure to the problem. The ICJ's opinion could clarify how this principle applies in practice and what it means for the legal obligations of both developed and developing countries. Second, the opinion will likely also draw on the duty of states to prevent transboundary harm. Under international law, states have a duty to prevent, reduce, and control the risk of environmental harm to other states. The ICJ's opinion could examine how this duty applies to the issue of climate change, given that greenhouse gas emissions have global consequences. And third, the opinion might also examine the relationship between climate change and human rights, as the impact of climate change can threaten the realization of various human rights, including the rights to life, health, food, and an adequate standard of living. The process of issuing an advisory opinion will formally begin within the next month or so when the UN General Assembly formally communicates its request for an advisory opinion to the International Court of Justice. The ICJ could decline to hear the case, though this would be a highly unusual move as its role of the principal judicial organ of the United Nations system sort of implicates it in these kinds of issues. While the ICJ has never declined a request in this way, if it views the request as political rather than legal, or if it views the request as a political action rather than a legal question, it may choose to do so. Though, as I said before, it would be highly unusual for the court to decline to take up a case like this. If the court takes up the request, it will likely give all interested parties at least 6 months to submit comments, either through written or oral submissions, and then several months more to respond to the testimony offered by any other party to the case. The court would then likely take several months to review the testimony and to write its opinion, meaning that any final decision or advisory opinion is at least 12 to 18 months away. Once the ICJ issues its advisory opinion, it could have far-reaching implications for global climate policy. While the opinion itself may not be legally binding, it could create a strong moral and legal impetus for countries to enhance their climate change commitments and to take on more ambitious action. Additionally, the opinion could force countries into future litigation related to climate change, both at the international and the national level, by providing a foundation for legal arguments in the and interpretation of states' obligations. Other courts, including the Inter-American Court for Human Rights and the International Tribunal for the Law of the Sea, are being asked to clarify and define law around climate change already. Such courts would no doubt look to any advisory opinion issued by the International Court of Justice as an influential precedent. That's it for today. I'll be releasing a follow-up video looking at Vanuatu's a lawsuit against the largest greenhouse gas emitting countries and companies soon. Be sure to subscribe if you want to catch that video or future explainers. If you found this video helpful, please give me a thumbs up, and if you have any questions about this video or suggestions for future topics, please leave those in the comments section below. Thanks for watching, everyone, and see you next time.